Good morning, everyone. My name is Stephanie Marshall, and I am the pro tem Kitsap County Hearings Examiner assigned to this matter. Today, this is an administrative appeal of permit 23. Actually, I think the appeal is permit 23-02934. And the decision on appeal is permit 22-02361. This is a preliminary plat short subdivision for Main Street cottages. And this is the time and place for the hearing. It is November 17th, 2023, 9:01 a.m. I will do a few introductory and disclosure type remarks, and we'll go over how the hearing will proceed. As I stated, I am the pro tem hearing examiner for Kitsap County. Let's see here. I was brought in recently, as many of you know. My colleague and friend Andrew Reeves has had to step back for personal reasons. Have gotten up to speed as quickly as possible on these matters, and have reviewed the record and have reviewed the motions and the witness lists, and am ready to proceed. I will state that I have no interest in the outcome of this appeal. I do not have an affiliation with the applicant or any of the appellants, and have not had a site visit. I've had, so I have no ex parte contacts, and I have no interest in the outcome of the litigation. I believe I can proceed to preside over this matter, and I am happy to answer any questions that you have of me. This is a quasi-judicial hearing, and it's de novo. So all evidence and testimony will be likely accepted into the record. We will address objections as they come. And what else can I share? Let me think. The hearing is scheduled for today. If there is a request for a continuance or a request to leave the record open, we can address that before the hearing is closed today. So now I will ask if anybody has any questions. Okay, and I understand from the clerk, Amanda Walston, that every 2 hours we need to take a short break so that they can catch up on recording and all that. So I will, have everybody kind of keep in mind that we'll take like a 10 or 15-minute break at 11 a.m. All right, so with all of that said, the way this will proceed is that we will hear from the appellant first, and they can present their case and their witnesses if they have any that they wish to call. And then we hear from the county, and the county will present witnesses and exhibits if to the extent that they have any, which, again, I've reviewed the lists, and it sounds like some of this might be abbreviated. And then finally, I will hear from the applicant's attorney, and they will have the opportunity to put on their case. Okay, all of that being said, I would like to call Landon. Landon, are you providing testimony today? Because if so, I'm going to need to swear you in.
Testimony? No, I'm not providing any testimony.
Okay.
Can I just mention a few things preliminarily?
Yes, please, David.
Okay, so I noticed the planning director, Jeff Remack, is on the appellant's witness list. He's only available 10 a.m. till noon today. And also, since there's only county staff on the appellant's witness list, I don't mind going first if that's what the appellant and the hearings examiner want. I've got Catherine Schaefer. We do have a hearings examiner rule that requires the county to make available staff that are necessary, but it's not unlimited, where you can't just list as many county staff as you want and tie them up for the entire day. So if we can get everything that we need, both sides, from one witness, that would be great, in my opinion.
Your Honor, if it also would help, I have 3 witnesses listed, but that was only if there's an issue other than the trees, because there's a bunch of issues in the appeal that I think the only issue to talk to the trees. If that's the case, we won't be providing any witnesses today, and it'll be just on the record.
Okay. Wow, this might be short. Okay. Well, I say your name wrong. Is it
Hito.
Akito?
Akohito.
Akihito. Thank you.
Okay.
It's a beautiful name. Okay, Mr. Akihito, Mr. Getches has proposed that he can proceed to call his witnesses, and you would be able to cross-examine his witnesses for the extent of presenting your case today. Do you have another way that you wish to proceed? Because technically you are up first.
Okay. So first, I will want to talk to Jeffrey Mack. There is evidence in the record in our filing that we want to go over, which includes him. And let's see. Oh, sorry, I'm not a lawyer, so I'm trying to figure this out.
Oh yeah, no.
Sorry. I guess we could call Miss Schaffer first, and then
I mean, yeah.
I mean, we would prefer to speak to Jeffrey Mack first, if that is possible. Oh, we prefer to, yeah. Okay. Let's go ahead and call. We'll go ahead and we'll go first. We'll start with Catherine Schaffer, and hopefully, Jeffrey Mack will be available by the time we finish questioning her. I did have a question about post-hearing briefs. I know that you had mentioned that they are available to do in written form. We would like to do that if possible. Is that something that you're open to? And what would the time be?
Yeah. Absolutely. I offered this at another hearing earlier this week, that the parties, instead of trying to summarize closing arguments during the hearing, could request that the record be left open for post-hearing briefs. That would not mean you get to put in new evidence, but you could put in a post-hearing brief, and we can look. I know next week is Thanksgiving. I was thinking a 7-day period, ending next Friday. But I'm amenable to other people's schedules, and would like to hear from the applicant and from the county as well on this.
Oh, post-hearing briefs are fine.
Okay,
I'm fine with that, Your Honor.
great. Mr. Akihito, sorry.
Yeah.
If I established a 1-week deadline for post-hearing briefs to be submitted to the county. Now that I think about that, is the county open on Friday? No. Okay.
No, it's a holiday for us. So Monday would be.
I was missing something. So okay. So then I would request that the briefs be submitted by November 27th, Monday. No sense in losing that additional time there. And Ms. Walston, at what time is a cutoff for the county for receipt of documents? Is it 4 p.m. or 5 p.m.?
Technically, it's 5 p.m. We're most of the office closes at 4:30. But
okay. All right. Well, I will. We will take this up now, and I am formally allowing the parties to submit written closing arguments, written post-hearing briefs, if you will, no later than Monday, November 27th. Submit as you have all your other materials in the manner that you've done so by 5 p.m. on 11/27/23.
Okay. Okay. I had one other question.
Yeah.
Andrew Reeves had mentioned in his pre-hearing conference that he would consider additional evidence at the time of hearing if he was compelled to. Is that something you're
Yes.
that you consider as well?
Yes. The record is still open right now, and this is your opportunity. In fact, that reminds me of another disclosure that I should have made. It's what we call the raise it or waive it. So if you have arguments and you have evidence that you want me to consider, now's your time, unless you ask that the record be left open. The oral order that I just made about post-hearing briefs is limited to the evidence that is presented, that has been admitted into the record through today, unless there is a separate request to leave the evidentiary record open.
Okay. So would I make that request now? Is that
Sure, we can address that now. If you have new evidence that you want to present,
Sure.
Written evidence that you want to present, and then I'd also look to the other parties to see if to the extent that it's a declaration, there may be a desire to reconvene the hearing so that cross-examination of a witness can take place. So there's kind of several parts to this. So first, let's start with what is your request?
Okay. I have a couple things. Some are so. One is DCD provides a webinar about tree harvest, and we created a transcript from that has relevant information to tree harvesting.
Mm-hmm.
So that was one thing. We have a PDF of that. I don't know. Do you need to see? So that's one.
Mm-hmm.
And then two is after the evidence deadline, we were able to obtain a tree board footage estimate from a wood milling company. And there's no board footage estimate in the foundational documents. And I feel like, I think that's going to be relevant information to this appeal hearing.
Do you have both of these items available today to be submitted today?
Yeah, they're both PDF.
Okay.
Yeah.
Okay. And then my next question is there additional evidence that you are either looking for or waiting to receive that for which a request to leave the record open would be based?
I don't think so.
Okay.
The only other question I had was, I wasn't sure if I could reference the KITSAP comprehensive plan. I know that we can reference code.
Yeah.
And so what's your ruling on that, would you say?
Yes, you may reference the Kitsap County Comprehensive Plan.
Awesome. Thank you.
You're welcome. So it sounds like if you have these documents and can transmit them as part of the appellant's exhibits, we may not need to leave the record open for additional evidence. Am I understanding that correctly?
Yeah, from our side, at least.
Okay. And what is, I'm interested in the county's response and Mr. Beebe's response for the applicant.
No objection.
Okay.
No objection here. I don't think we need to leave the record open if he has them available to file.
I agree.
Good.
Yeah, I agree. I'd prefer to close the record today at the end of the hearing, just only allowing for post-hearing briefs. Okay. Did you have other preliminary questions, Mr. Acohido?
Let me check. Just
Briefly.
do you have do you know what the post-hearing brief length should be?
That's a great question. what is I think the rules allow 12 pages.
Mhm.
I think it's 15.
15. Yes. Yes. So 15. If you feel like you need more than that, you may accompany your brief with a request to file an overlength brief.
Okay.
But I guess I'd say, I'd caution just that, usually 15 pages is sufficient. Not that I'm going to deny a request for overlength, but to the extent you can keep it within the 15 pages, that would be much appreciated.
And thanks for being patient with me. I'm
Oh,
kind of
yeah.
like I'm being shot out of a cannon right now. So I'm like, anyway. Yeah, I think that's all the questions. Do you need me to transmit the evidence now somehow?
We can address that later before the hearing ends today. But sure, I mean, and we can coordinate with Ms. Walston as to receiving that evidence.
Okay.
Because she will assign numbers to it.
Okay. And so am I able to use the evidence in my crossing examinations?
Yeah, absolutely.
Great. Okay.
Okay.
Um,
So it sounds like you'd like to proceed with Ms. Schaefer first, and Jeffrey Mackey will be available after 10. I know he's only available from 10 to 12. So if we start with Ms. Schaefer, then we'll see how long we go with her. She's also on the county's list.
Okay. Oh, I have one other question. Sorry.
Yeah.
Is Peggy Bakalarski no longer with DCD? I couldn't figure that one out.
She's
Or
still there.
She's here. She's online too. She's available.
Okay. Okay. Great.
Okay.
Okay, are we ready for Catherine Schaefer then?
Yes.
Okay. Is she on?
She's coming on.
Good morning.
Morning.
Hi.
Thank you for being here. I'm the hearing examiner. I'm going to have you raise your right hand so I can swear you in. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Okay, Mr. Akihito, you may begin your questioning.
Okay. Good morning, Ms. Schaefer.
Good morning.
Go ahead and introduce yourself, your position, and maybe how long you've held your position.
Sure. My name is Catherine Schaefer, and I am a planning supervisor, and I've held this position since January 9th, 2023.
Okay. And then, do you know a Miss Jennifer Kreifels?
I do.
And what is her position?
Her position is planner.
Okay. And how long has she held that position?
February of 2023, I believe.
Okay.
But early 2023.
Okay. Okay. I'm just gonna pull up something here. Let's go ahead. I'm gonna share my screen. And where's my share screen? More share screen. Okay. I am gonna. Okay. I'm just gonna. I'm bringing up your declaration.
Sure.
So we can go over it. And let me see here. Okay. Let's see. So you recognize this document. This is your declaration.
Yes.
Okay. And you provided this on October 10th as a sworn declaration about the DCD site's assessment and permitting process around this development. Is that correct?
Yes.
So were you involved with the preliminary approval review process?
Yes.
Um, how far along was the application when you came into the process? Did you start from the start?
Yes, I did.
Okay, because I thought it says here. Can you see that? Can you see my screen?
Yes.
It says I've held my current position as planning supervisor for the past 10 months. Is that you were still involved prior to that 10 months? Or because I think the application was filed in June of
Correct.
20.
It
Okay.
was. Unfortunately, due to staffing issues, we were very backlogged. So I was the first person to review it when I came back in 2023.
Okay,
So it unfortunately did sit there for a while before we were able to review it.
okay.
Yeah.
Okay. And then are you a signatory on the application approval itself?
On the application?
Well, on the preliminary approval, I mean.
So I'm not. It's Peggy Bakalarski's signature.
Okay.
However, that document is a group effort. She compiles all of the conditions to create that letter. So though it is her signature, there's a paragraph at the bottom that mentions everybody who worked on it. For example, the land use section would be, mine and Jennifer Kreifel's, and then there's a stormwater section. So it is a group effort.
Okay. Okay, gotcha. Okay. Let's go to statement 11. Would you mind reading statement 11, or do you want me to read it?
I'm happy to read it.
Okay, that'd be great.
The subject property is 0.37 acres and zoned urban village center, UVC, which has a minimum density of 10 units per acre. Minimum density is based on net developable area, Kitsap County Code. Net developable area based on definition 17-100-507. The application for Main Street Cottages short plat was determined to have a net developable area of 0.23 after subtracting the easement track A recreation area and track A. Okay, so 0.23 of net developable area multiplied by 10, which is the minimum density, equals 2.3 acres. Kitsap County Code 17-420-020 requires to round down when you have less than a half. The calculation was made during the permit review. At 2 was the minimum density. The UVC zone does not have a maximum density. So
Okay.
I would also like to add to this. So this was October 14th that I did this. Preparing for the hearing, I would actually like to retract that. I should not have subtracted the easement as part of net developable area. If you look at the definition of net developable area in our code, it says to subtract rights of ways. And I considered the easement a right of way. I think that was an error. So that easement should be taken out. And the difference between right of way and easement is right of way, anyone can use it. And then an easement is specific to a certain group of properties. So with that, I would like to say that I think the new net developable area is 0.35. So if we then, I'm sorry, Cat. If we then multiply 0.35 times 10, we get 3.5, and then we round up to 4. So I do believe that 4 is the minimum density.
Okay. So you said that that this was made during the review permit
Yes,
process.
that is the determination I made during the review.
Okay, so you were under the impression that it was 2 during the review
Correct.
process. Okay. Okay. Let me just review my notes. Okay. Let's move on to statement 6 and 7. Okay. Can you go ahead and read statement 6 and 7?
Sure. All development permits review the proposed clearing limits to evaluate whether the proposal triggers the need for a timber harvest permit. This proposal to remove existing trees for development did not require a timber harvest permit because the amount of timber on the 0.37 acre parcel is less than the amount that requires a permit.
So would you say you were the one that made the decision not to require a tree harvest permit?
Yes.
Okay.
I would also like to keep in mind that to develop something like this, there are 3 different permits involved. This is a preliminary plat. So this is essentially breaking up from 1 piece to 4 pieces. We're also going to have a site development activity permit, which is currently under review for this project. And we further evaluate timber harvest during that permit as well. So it's not just, at this moment, I decided that was not required and I'm never going to think about it again. It is evaluated again at the site development activity permit review.
Okay. Okay, so let me bring up another one. We'll kind of jump back and forth. So were you aware that there had been a timber harvest application done in 2019?
On the subject property?
Yeah.
No, I was not.
Okay. I have it here. I just got to find it. Okay. And if it were to require a timber harvest permit, would it require also a DNR application?
Yeah.
Okay. And what's entailed in that? Why is that a necessary permit?
It's to report it to DNR.
Okay.
I'm here.
Oh, sorry. Siri just went off. Sorry. Okay. So when you decided it didn't need a timber harvest permit, did you make a rough calculation of the board footage?
No, I did not.
Okay, so how did you determine that it didn't need a timber harvest permit then?
It appeared that there were only like 5 trees from the aerial that I was looking at.
Okay.
So again, when we do a preliminary plat, we're more looking at the division of the land. And then at site development activity permit, we're more focused on the actual ground disturbance.
Okay. Did you see this document in your review?
So yes, but this might be an SDAP document. I don't know if this was a preliminary plat or SDAP, but I did see this document.
Okay. So according to this document, there's, it lists 12 trees.
Okay. Yeah.
Yeah. And do you know if the southern 2 trees here, are those going to stay or are those going to be removed as well?
Those are not part of the subject property, and so the applicant would have no rights to remove them.
Okay. And the driveway approach would not affect those being so close?
It's my understanding they're going to stay, as like I said, it's not on the subject property.
Okay. 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 So if the parcel does have more than 5,000 board feet, in my understanding, is it standard for the county to add an environmental condition requiring a timber harvest permit?
Yep, correct. We would do that at the site development activity permit with that permit.
And not on the preliminary approval letter?
No, we would not.
I've seen, I don't have anything in
yeah, we may condition timber, like we might put a condition at like if we can tell automatically that it's over 5,000 board feet, we can definitely condition the preliminary plat to require that. But if we don't put it on the preliminary plat, that's not to say we can't require it at the SDAP.
Okay. Okay. Um, so going back to the minimum density, you're saying that's an error.
Correct. I don't think I should have subtracted the easement. The recreation track should be subtracted because it's listed in net developable area, the definition. So, but the easement should not have been deducted. And I believe the easement was 0.12.
But this was a sworn statement, correct?
Correct. In October.
Okay.
Since then, I've, with my preparation for this, I've seen the error.
Okay. And you know for sure that the easement shouldn't be retracted?
So if you look at the definition of net developable area, it says rights of way should be subtracted, so it should be deducted from that. And an easement is not a right of way that's granted to everybody. It's just granted to those in this plat. So it shouldn't be subtracted. Now, if it were a right of way for everyone, that'd be different.
Gotcha. Okay. Okay. Oh, so when going back to the board footage, what method does the county use to actually estimate the board footage?
So we look at aerial photos, and we also will take advantage of Google Earth or Street View to make an estimate.
Okay. Okay. Do you use like Doyle's or Scribner method to estimate tree, or the international quarter-inch rule to estimate board footage?
I have not heard of any of those, so no.
Okay. Those are some of the most common ways, I guess.
Okay.
So you don't know the board footage then? Is that correct?
No, not exactly.
Okay. And so I guess that would mean that you don't know whether it would need a timber harvest permit or not.
Not at the preliminary level.
Okay. Let me go back here and just see something. You said on statement 7, this proposal to remove existing trees for development did not require a tree harvest permit.
Yeah, at the preliminary level, correct.
Okay. But okay. So if you don't know the board footage, can you say that you really considered the trees in the review process?
Yeah, I consider the trees.
I'm sorry, I'm just trying to think through this. I don't know how that. So what is the county's calculator for board footage?
We look at square footage a lot too. So if we have a vacant piece of land, we'll take a look at how much is being cleared. Like I said, we look a lot at aerial photos. And a lot of times inspectors will also help us as well. They'll go to the site for us.
Okay. And then they'll give you a board footage estimate?
Yeah.
Okay. Have you ever been on this site?
I have not.
In person? Okay. 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 I'm going to bring in, if it's okay, hearing examiner to bring in that board footage estimate from the wood miller. Okay. Okay, so I sent to Mr. Spencer West. He is according to his email, I base these estimates from my 20 years of experience operating a mobile sawmill in Kitsap County, milling trees of these species and dimensions, as well as referring to the Scribner log scale for log volume data. I provided Mr. West rough tree heights and the diameters that were listed in that previous area, that previous site plan that showed the trees. And I took the numbers straight from there, provided them to him. And he came up with a board footage of 12,755. Ms. Schaefer, would you describe that as over the board footage amount?
If that's accurate, yes.
Okay. And that's more than double the amount.
Yeah.
Okay. So would you say that, looking at it, that it wasn't looking at the clearing limits? Let me go back. I wish I had these all up at the same time. So would you at this time say that this property would need a timber harvest permit?
If those numbers are accurate, yes. But again, we have that opportunity at the site development activity permit.
Why would you choose to skip it on the preliminary approval for this case?
Well, when I did the preliminary approval, it didn't jump out to me that it was 5,000 board feet. Sometimes it's obvious that it's 5,000 board feet. In this case, to me, it wasn't jump out obvious.
Mm-hmm.
So, but again, it's not the only opportunity we have. And the site development activity permit is more about the ground disturbance than the preliminary approval is.
Okay. Okay. I'm just going to move on. So besides, in this case, there's perhaps the need for a timber harvest permit. And you mentioned there a tree length and a half. Would that also need a danger tree timber harvest permit, or would one supplant the other?
So the SDAP would cover the clearing. Now, say those houses were already developed and they were within a tree length and a half, that's when the danger tree permit would be appropriate. Mm-hmm. But the SDAP covers that, that clearing.
Mm-hmm. And if there's a need for a timber harvest permit, is there a moratorium on parcels if they're logged without a timber harvest permit?
Yes.
And what are those consequences?
6 years, no permits issued.
Okay. Okay. And so there are consequences for clearing without a permit, correct?
Yes.
How about clearing in general without a permit? The clearing the understory of a tree without a permit.
Are you stumping? Are there ground disturbance? Are you just cutting? There's a lot of different scenarios.
What about ground disturbance?
Ground disturbance, there are thresholds for ground disturbance that trigger the need of a permit.
What are those thresholds?
Gosh, I apologize. It's escaping me right now, but there are threshold standards.
Okay. So if it met the threshold, what kind of consequences would there be?
They would most likely they would be an after the fact SDAP or some sort of grading permit.
Okay. So So it's not as hard. Would you characterize it as not as harsh as a logging without a permit?
No, I
Okay.
don't think it is.
Okay. Um, okay. Um, oh yeah. So do you know if this short plat application will remove stumps?
I would assume yes.
Yeah. Okay. And will it be grading over 7,000 square feet?
I don't know the grading quantities,
Okay.
but that's in the SDAP. But I don't know the grading quantities off the top of my head.
Okay. I mean, I've calculated 0.23 to be a little over 10,000 square feet. So I'm guessing 0.35 would be more than that. Um, so, um, okay. Um, okay. All right. Let's go ahead and read statement 8, if you would, please, Ms. Schaefer.
Yeah. However, when staff reviewed the clearing limits and the Kingston design standards, we considered the on-site trees danger trees.
Okay. What do you mean by staff reviewing clearing limits and Kingston design standards? What's review clearing limits mean?
See how much clearing they're going to do on a proposed property, on the subject property.
Okay, so that you would know then the square footage of the grade at that point.
The
You would know,
grading.
yeah, you would know. Well, I mean, if you're reviewing the clearing limits, then you would know the square footage of the property, correct?
Yeah.
Okay. Okay. Um, sorry, it's taking a little longer.
No problem.
Yeah, clearing limits has to do with knowing the board footage, correct? Of the trees.
I see clearing limits as more of like if you take a parcel and you kind of circle around what's going to be removed. And then to me, the board feet is another calculation. So we want to look and see how much ground disturbances there's going to be. That to me, that's the clearing limits. And then the board feet's another calculation.
So you're saying clearing limits does not include, it includes horizontal clearing limits, but not vertical clearing limits?
Yeah, I do. Because when we look at it in the office, we want people to show the clearing limits on their site plan. Kind of difficult to show on a flat piece of paper, how high things are. So I really consider those two separate.
So at what threshold would you, during the preliminary process, decide that, hey, this property needs a timber harvest permit?
Well, like I mentioned before, sometimes it just super jumps out at you. Like, for example, if it were a heavily treed half-acre property that they were going to put a straight plat, not a short plat. It's like, okay, this triggers 5,000 board feet, hands down. So in this case, though your calculation did show that it was 12,000 square feet, because of the amount of trees, you said about 12, it's a lot harder to calculate that at the preliminary level because we're more looking at divvying up or dividing that property from 1 to 4.
So would you say that you don't usually deal with trees of this size?
No, I don't think I shouldn't say never, but a lot of times short plats in an urban growth area do not have trees this large or this tall, I should say. for in an urban setting at least.
Okay. Were you aware that the community had mentioned the size of these trees in their emails when the application was first notified to the neighborhood?
Yeah, I believe that came in through the notice of application.
Did you take those into account when deciding on a permit? But I mean, if the public's telling you, hey, these are huge trees, wouldn't that trigger some sort of thought process that like, hey, I should probably check this out. They see these trees as significant, and maybe we should determine, the size of these trees that the developer is planning on just, mentioning, hey, there's just some trees we're going to cut down real quick. Is that fair to say?
Yeah, I think that's fair.
Okay. So you didn't consider the trees during the preliminary review process then?
I considered them.
No, but you didn't. You just said that you didn't. Did you consider the retainment of them per KDS?
No, I considered them danger trees.
Okay. Okay, go ahead and read statement 8, please.
However, when staff reviewed the clearing limits in Kingston design centers, we considered the on-site trees danger trees.
Okay. So in your declaration, you state that you consider them danger trees, correct?
Correct.
Okay. I'm going to pull up definition from definitions. This is the Title 18 danger tree definition, J. I'll go ahead and read it, I guess. Danger trees pursuant to the Critical Areas Ordinance, Title 19, and as hereafter amended, quote, danger trees means any tree of any height, dead or alive, that presents a hazard to the public because of rot, root system, or limb damage, lean, or any other observable condition created by natural process or man-made activity consistent with WAC 29654-505. Can you tell me how these trees fit into this definition, please?
Sure. Other observable condition created by natural process or man-made activity.
What man-made activity?
Village green to the west. The clearing of that created these as danger trees.
In what did you observe?
That these trees, if they fell to the west, would hit village green.
Yeah, but that's not a definition of a danger tree. Falling to the west is not a definition of danger tree.
It's a man-made activity that put a structure at risk.
How did that, again, how does that fit into this definition? I don't understand. If they were going to construct,
It's a hazard to the public.
or if they were going to construct a retirement center right next to these trees, wouldn't the danger tree aspect have come into play then?
So the subject property, the trees are on the subject property. So the village green, when it was constructed, could not remove those trees. They didn't have any right. So if you look at aerials prior to village green, there's a whole host of trees that were removed for that. These were left remaining of that kind of group of trees because they were on the subject property. So the village green were not able to legally clear them.
So they chose to site the retirement center next to your definition of danger trees, knowing that they were dangerous at that point.
Well, a lot of clearing was done to do the village green.
Well, that's not what I'm asking. I'm asking, so DCD approved a retirement center of 40 homes next to danger trees is what you're saying.
So the Village Green, I believe, was constructed in 2013, and these trees may not have been that large at that time. So
That's not, you're not seriously saying that, are you?
I'm under oath. I'm just saying that the Village Green was constructed a long time ago.
That's 10 years ago.
And I'm guessing with my 2013 date, but it's early. So.
Yeah, no, I think it's 2013 as well.
Yeah.
These trees surely didn't grow, 50 or 75 feet in 10 years.
Well, again,
Correct.
I haven't been on site to really understand the relative.
So you haven't been on site, so you haven't really considered these trees then, because you haven't been on site.
I considered them danger trees.
But how does that fit into the danger tree definition?
Presents hazard to public because of a man-made activity.
Yeah, but can I read you the last part? Presents a hazard to the public because of rot, because of root system or limb damage, because of lean or any other observable condition created by natural process or man-made activity. Mm-hmm. So does it have root? Have you been on site to see if it has root or system or limb damage?
I have seen pictures, and I do think one of the trees does not look like it's considered healthy.
So one of the trees, and did you have an arborist or a trained professional tell you that, or is this your opinion?
So Steve Heacock went, looked at it. He's our tree guru in the office, and he looked at it with me.
Okay. He looked at it with you. How? Because you haven't been on site.
We have pictures.
Okay. So one tree presented a danger in your opinion?
Yeah.
Okay, so one tree was dangerous.
That jumped out at me.
So you took one tree that you considered dangerous, you and Steve Heacock, and decided to apply that to all 10 or 11 trees. Is that how that worked?
No, we looked at a picture, and one definitely jumped out at us as looking not healthy.
Would you say that it would probably make sense to go on site to see these trees before making a blanket designation of danger tree to all the trees?
We do not have the resources to visit every site. We cannot do it. Yeah.
I got it. So you didn't really consider all the trees danger trees then?
I did.
Based on what? Based on one picture?
Could I object for a moment? Because I think the problem here is he's using a definition of danger trees per the critical areas ordinance, and this isn't a critical area. That I think what he needs to refer to is the code Kitsap County Code 18.16 that defines the danger trees as 150% of their height. So the tallest tree here is 240-foot fall radio, and I think that's kind of getting lost in the translation. Thank you. I'll be quiet now.
Thank you, Mr. Beebe.
I don't see that 150%.
Where is the code?
Where is that in code?
We're looking. This is
the whole title is 18.16. So let's see.
Does Mr. Beebe want to provide a number?
Is Mr. Beebe referring to tree and a half? Is that what he's referring to?
Yes, the tree and a half restrictions. And if you look on the explanation, it's not the webinar, but the PDF that you filed and I filed, it defines how they come to that determination. So that your 160-foot tree being the tallest, the fall area is 240 feet, which includes for any permanent structure. So
that's permit application criteria and not the definition of a danger tree.
I understand that, but I think what's being lost in the translation here is when Ms. Schaefer, I won't speak for her, but she's applying that standard to if a danger tree application is needed.
Yeah, but that would just signify it needing a timber harvest permit or a danger timber harvest permit, and you would need to know
I
more.
I won't argue with you. I just think that we're getting a lot between trying to define each
I
individual
guess
tree.
what I'm trying to figure
Thanks,
out is,
Landon.
yes, thanks, Keith. What I'm trying to figure out is whether Miss Schaefer truly considered the trees. She says, Miss Schaefer, you say that you talked to Steve Heacock and one tree appeared to be unhealthy, and that from a picture you decided they were all danger trees. Is that correct?
I didn't necessarily say, yeah, I considered them all danger trees, correct?
Okay. Would you say that was sufficient to call the 8 legacy trees, or depending on how you look at it, 10 to 12 legacy trees, to make that blanket statement that they're all danger trees? Do you think that's sufficient criteria to do that, to do so?
Well, keep in mind, when developing, if they were going to put units on there, they would become even more dangerous trees because of the proposed units going close to the trees. So it's not just the existing buildings, it's the proposed buildings as well.
Yeah, but are they danger trees as they stand now is my question.
I think it could be argued that they are because of the village green, but let's not worry about village green. You know, we're talking about the short plat here. We also want to, it's also within DC.
That's my only question about that. Okay, let's go ahead and look at statement. Can't get to it. Okay. Can you go ahead and read statement 9?
Yeah, even without the proposed Main Street cottages preliminary short plat, the existing trees are within a tree length and a half of the village green to the west.
What's that mean?
That means that, say, Village Green went to the property owners and they were like, hey, I'm really worried about these trees falling on our property. I think they could argue or ask the applicant or the owner of the property, hey, could you remove those? Because I'm worried about them. I think that's
so you're assuming that there's residents that see them as dangerous?
No, I'm not assuming.
Has anybody called you about these trees?
No.
Okay, so nobody in the neighborhood has called and designated them dangerous at this point?
No.
Okay. So also, is there a minimum distance in code to how close a structure can be built near a tree?
We used the tree length and a half, but if someone wanted to have a tree closer, they could.
Yeah, but is there a minimum distance in code?
No, I don't think so.
Okay.
We are the fire district looks at the WUI code, which is the Urban Wildlife Interface code.
Yeah, that's okay. That code isn't adopted yet. So
yeah, no, yeah, we just got some training on it. So
yeah, okay. I'm gonna bring up the other piece of evidence that I submitted today, the transcript from DCD's webinar about timber harvest. Okay. So um this is a DCD timber harvest and tree removal webinar on YouTube on DCD's YouTube page. And I took the liberty to transcribe minute 23 through 24. And this was in regard to danger trees, or danger tree permits, I think. So Eugenie says she's answering a question from a participant. Is there a minimum distance between your future home and trees? It sounds like there must be a 1.5 tree distance, but it might be for when a permit is required. And then Scott Diner says, I'll just read the highlights. There is no minimum. We do not specify or have in code a minimum distance. Steve, you want to elaborate? Steve says, a lot of people choose to minimize the amount of tree removal they do, which is fine. As long as the trees are healthy, I would suggest getting an arborist to take a look, but there's no requirement. So would you say given that there's no requirement in code about minimum distances?
No, there isn't.
Let's go back. So just to reiterate, you're confident that these trees are dangerous?
Yes.
As they stand.
As well, again, it's about the proposal. I think that we're creating a situation that may be unsafe if we put homes on the subject property. Now, just because there is no minimum doesn't mean that everyone's comfortable having a giant tree 2 feet from their house. I've had 2 friends have trees fall on their house.
But there is no minimum distance.
There is no minimum, correct. But again,
if they're not dangerous as they stand now, correct?
I think that's debatable. But again, we're talking about the preliminary short plat.
Okay. Okay. Let's see. Sorry, I'm just reading through my notes.
Okay.
Can you read the highlighted 12 through 14, please?
Sure. On February 7th, 2023, staff requested a narrative describing how the project met the Kingston design standards. Applicant's landscape plan is consistent with plans in Kingston urban growth area and uses plants from the approved list in the Kingston urban design standards. The landscaping is similar to the village green adjacent development properties on these streets, and even the appellant's property in the neighborhood.
So you state the applicant's landscape plan uses plants from the approved list in the Kingston design standards, correct?
So it's conditioned that way.
Okay. This is a reference to chapter 5, section D, correct?
I don't know the citing off the top of my head.
Okay. Have you read the Kingston design standard in its entirety? Or how do you guys use it? Do you just reference it, or do you? Sorry. Yeah.
Yeah, we use it.
Okay. And do you read the entire thing when you apply it?
Yeah.
Okay. So you required the applicant to comply. So chapter 5, section A is landscape plan requirement. Is that the provision you required the applicant to fulfill?
I apologize. I don't know off the top of my head. But again, what we do at the preliminary plat level is we just kind of make sure it's conceptual. So then when we get to SDAP, that's when we get into the nitty gritty, really looking at very specific plants and spacing and things like that. So at this level, it's very, very conceptual.
Okay. Let me see. All right. I scroll all the way through. Okay. So this is chapter 5, section A, landscape plan concept. And number 1 reads landscape plan requirements, correct?
Yeah.
Okay. And then it says A, submit a landscape design plan and be prepared to demonstrate that the plan addresses the following considerations. You see that part?
Yeah.
Okay. And jump down to bullet point 5. And it says protection of existing significant trees and natural site amenities. So to read that in full, submit a landscape design plan and be prepared to demonstrate that the plan addresses the following considerations: protection of existing significant trees and natural site amenities. Did you require the applicant to fulfill this landscape plan requirement?
It's, again, it was conceptual at the preliminary plat, and then we will jump into it at the SDAP. So it is a requirement, just not at this level.
Okay. So the problem I have, or the way I'm thinking of this is, if you get it through preliminary approval and say you had to have a requirement that showed the protection of trees, are you going to then potentially change the site plans at that point as opposed to the preliminary approval point when it would be early enough to do so?
Yeah, we would change it at SDAP. Again, preliminary approval is the division of the land. They can change, for example, the house footprint isn't isn't set in stone. They can move it at SDAP. We're dividing the land at that point.
Right. But wouldn't that, I mean, if you divided the land would inherently dividing in the land would inherently conflict with retaining trees at that point, right? Because you would have created 4 smaller lots.
I don't think so. I mean, if you just create a lot with nothing on it, the tree
Well, it had trees to be retained on it.
Yeah.
So if you split it into 4, then you're now putting the trees in certain peril at that point, correct?
I mean, I don't think the trees are still there, whether it's one giant parcel or 4 smaller ones.
It's a stand of trees, so you're dividing up that stand of trees, correct? By preliminarily short platting it?
No, you're just, when I say divide the land, I'm thinking of more of like the assessor's office sees it as 0.37, and now it's going to see it as 4 smaller lots. So that's when we get into the SDAP, is when we get to the ground disturbance.
Right. So I guess going back, wouldn't it be important to assess the tree's significance during preliminary short plat approval than to allow the short plat to go through and then try to assess the significance of trees and the retainment of trees?
Can you repeat that?
Wouldn't it be important to assess the retainment of trees prior to preliminary short plat?
Yeah, we assess the trees at preliminary short plat. Yeah,
and the retainment of them?
Yeah, that's something that we look at any short plat at that time. But again, we get into the nitty-gritty details of the landscape plan at SDAP, not at preliminary approval. We get a conceptual, for a short plat, we get a conceptual landscape plan And then when we get into the SDAP is when we really dive into it. Into like the plantings, the spacings, the.
Are you saying it's your guys' kind of choice on whether to designate, to consider trees at preliminary short plat approval or during the SDAP?
So we consider it at both. What I'm saying is the landscaping plan is when we get into more detail with what they're going to be putting in.
So is it county policy to divide stands of trees prior to fully considering them?
No?
Okay, so then you would need to consider them for retainment first, correct? In the preliminary.
Yeah, yeah, correct.
Okay, thank you. I'm gonna look through to make sure I didn't miss anything else. Okay, let me just go through my notes here. 1 second. Mhm. So, you're aware of this document, the KDS, correct?
Yes.
Okay. Are you aware that it's adopted into Kitsap County Code Title 17?
Yes.
Okay. And do you know per the footnote 5 in Title 17 420? I can bring it up actually, just so we can all look at it. Okay, here we go. So footnote 5, the design standards for the community of Kingston sets forth policies and regulations for properties within the downtown area of Kingston. All development within this area must be consistent with these standards in Chapter 17. Do you agree with that?
Yeah.
Do you acknowledge it? Okay. Okay, and then I'm going to go back to the KDS itself. Unfortunately, I have to scroll because it's 75 pages long. Okay. Let me first go back to your statement. Okay. Okay. So this is in David Getches's statement, kind of summarizing your declaration. And it says, the county complied with the design standards by determining no safe alternatives exist that would allow the project to meet minimum density without removing the existing trees. Would you characterize that as correct in your view?
I would.
Okay. Okay. So would you say that the retainment of trees actually conflicts with the minimum density allowed on that lot?
No safe alternative. Yeah. I don't think it conflicts.
How?
I think that we need to remove the trees in order to create a safe environment where 4 new houses would be. And that's the minimum amount required on the parcel.
So you're saying it conflicts with that the development conflicts with retaining existing trees.
The minimum density?
Yeah.
So
Because the minimum density would be what you're constructing, right?
yeah, it's built to minimum density. So
Yeah, so then it conflicts with the retainment of existing trees, right?
well, I would also say that I think there is some discretion in the Kingston design standards where it says that staff may require I think the language is something like alternate.
I'm not asking
plans.
that. I'm asking if the state, if the construction of 4 units at minimum density conflicts with the retainment of existing trees.
I don't think it conflicts in the sense that you're reading an objective. You are not reading something.
That's a provision.
It's a provision. Yeah, it's an objective.
Yeah,
So.
a provision is a provision as part of the ordinance. So, so you maintain that it doesn't conflict.
So I guess I'm just kind of, I don't think it's exactly black and white.
Can you keep the trees?
Okay.
And build 4 houses, in your opinion?
In that particular property, I don't think you can.
Okay, so
only 0.37 acres. It's pretty small.
Then it conflicts, correct?
In this case, I think it would be difficult to build those 4 houses and keep the trees.
Okay. Okay, so are you aware of the conflict clause in the KDS?
Correct.
Okay, I'm just going to read it. Where the provisions of these design standards conflict with other provisions in Kitsap County Code, the provisions in these design standards shall apply. How do you take that to how do you interpret that clause?
That the design standards would supersede.
Okay. So by supersede would mean take priority, be more important, things of that nature.
Correct.
Okay. And you recognize this as a conflict clause, correct?
Yeah, it's in there.
In your view, is it better to find a harmonious solution to avoid conflict among provisions? So saying if you have 2 provisions that potentially conflict, is it better to find a harmonious solution than to pick one over the other?
I want a solution. Harmonious.
Okay. So, okay, that's fine. Okay. I'm just gonna pull up 17. Okay. I'm just gonna highlight provision Title 17 100-050 conflict with other regulations. Where conflicts occur between the provisions of this title and other applicable code provisions or other regulations from other jurisdictions with authority, the more restrictive shall apply. Do you acknowledge this statement?
Yeah.
So given this conflict clause, which is to act more restrictively, paired with the KDS's conflict clause, which says that the KDS shall supersede other codes. Would you say that the KDS has primacy when it comes to evaluating site developments in regards to anything in the KDS, but specifically retention of trees in our case?
Can you repeat that?
Would you say that given these two conflict clauses, one is to be restrictive, correct? And the other one is that the KDS supersedes county code. Would you say that the KDS is the primary source for which you evaluate site plans from applicants?
So I wouldn't say that KDS supersedes all code. We do have safety code. For example, I don't think the KDS would supersede something like fire code and things like that. So I wouldn't blanket statement that it just supersedes all of our code.
Right. But does it supersede minimum density code? Minimum density requirements?
Well, there aren't any density requirements in the KDS.
Minimum density requirements.
Or minimum density. There's no density requirements in KDS. So I'm not sure how it would supersede it.
No, the retention of trees would supersede minimum density.
Objection. There's nothing in the KDS that requires retention of trees. So unless you can point to something that actually requires it, then we're wasting our time looking for a conflict. If it says may retain, then you haven't pointed to any requirement. You have to point to a requirement in order to establish any kind of a conflict.
And if I can piggyback, these are design standards that replace the county's design standards, if you look at the definition at the top. Thank you.
I'm just going to reiterate that there's a conflict clause in the KDS for these provisions and that they should supersede.
That's been established, but he hasn't pointed to anything that requires retention of trees that would conflict with the minimum density standards.
I'm going to jump in, you all. So I understand that Mr. Akahito is trying to see if he can get certain admissions from Ms. Schaefer as to what was reviewed, what wasn't reviewed. At this point, I will suggest that some of the questions, either some of these matters that we're delving into and continuing to try to get an admission might be better suited for a written argument. And I'm not saying I don't want to hear it anymore.
Yeah. I have just one or two more questions.
Okay, thank you.
So if we go down to Chapter 5, Section C, it's entitled Retention of Significant Trees. And Ms. Schaefer, under 1, significant tree protection, it does say, consider alternative building and parking siting strategies to preserve existing trees. Did you, do you or any other staff member consider alternative building and parking siting strategies to preserve these existing trees?
We did not. We felt that the parcel was too small for that.
Okay, thank you. Okay, I think that's all. Thank you, Ms. Schaefer.
Thank you.
Thank you, Mr. Akahito. I think I will turn first to Mr. Getchis. Mr. Getchis, do you want to cross-examine?
Is it possible we have one more question?
Oh, absolutely.
Okay. Oh, okay. Just one other thing from your statement, just to get on record. One second. Okay, could you please, are you still there?
Yeah, sorry.
No, I accidentally went away. It wasn't showing up for some reason. Okay, would you mind reading statement 15?
You'll have to reshare your screen.
Oh, it's not shared.
Yeah.
Okay. I don't know what happened. Let's see more. Share screen. Okay. Are you seeing it? I'll try to zoom in here. There we go. Statement 15, if you wouldn't mind reading, please.
Yeah, absolutely. The few large native trees do not function well as urban landscaping and constitute danger/fall risk to any nearby habitable dwellings. The trees are already within 150% of the height of too numerous habitable dwellings.
Okay, so is this an official county statement or your own personal opinion?
Well, it's county statement in the sense that I signed the document and under county, but it is in code. What Mr. Beebe was referencing earlier in Title 18, it's that 150%.
Okay, how about the few large native trees do not function well as urban landscaping? Is that your opinion?
Yeah, remember earlier when I mentioned that a lot of the short plats or preliminary plats that we do in urban zones don't have these really high, large trees because of the fall risks. Well, not necessarily. It is kind of rare in an urban setting to have those kind of large trees. So they do constitute that fall risk to properties in the vicinity.
So you define these trees as rare then?
Rare in the sense that if we do urban plats, typically they don't have this kind of landscaping.
Okay. I'm just gonna pull up one more, maybe one or two more. Okay, can you see this document?
Yeah.
It's the titled 2024 Urban and Community Forestry Assistance Grants Applications. It's published by the Washington State Department of Natural Resources. And to sum up, DNR is basically handing out $7 million in grants to promote urban forestry. Are you aware that this grant exists?
Nope.
Okay. Would you? Okay. This line here, investment in urban trees and forests supports cost-effective strategies to reduce flooding, summer heat, and pollution, and helps communities become greener, healthier, and more resilient. Do you acknowledge that statement from the DNR?
I see it.
Okay. Do you agree with it, in your opinion?
I don't have an opinion either way.
Would you say that the DNR is characterizing urban trees as good urban design or bad urban design?
It looks like they're talking about investments and they have strategies
in urban trees and forests, and their cost-effective strategies to reduce flooding, summer heat, and pollution, and help communities become greener, healthier, and more resilient.
That's what it says.
Would you say they're characterizing urban, how do you put it, urban trees as bad urban design, or good urban design?
Yeah, good.
Okay.
Well, keep in mind that this plat is conditioned to have trees in it. So it's not like there'll be no trees. There'll be trees replanted.
Right. But you are also supposed to consider site plans to retain the existing trees, correct?
That is a consideration, yes.
Your Honor, I'd like to object. I think we're speculating because we've just spent a half hour agreeing that Kingston design standards have primacy. And now we're talking about DNR grant programs to apply to this property. I think you got to
That's
pick
fine.
one or the other.
That's fine. That's fine. One last thing, and then we'll be done. I promise.
Okay.
Um, okay. Would you mind reading section C's objectives?
Sure. C, retention of significant trees. Objectives. To retain substantial natural vegetation. To preserve and protect stands of mature trees. To aid in stabilization of soil by preventing erosion. To reduce stormwater runoff and costs associated with it. To provide an important visual buffer and screening against traffic and noise. To conserve and enhance the unique character of the area and protect and increase property values.
Good. By allowing the removal of all the trees, do you meet any of these objectives?
No, I don't think the
Okay.
way that the project was designed, these objectives were not going to be able to be met.
Okay. Okay. And so the second objective, to preserve and protect stands of mature trees, would you say that that goes against your opinion that these trees are bad urban design, given this is the Kingston design standards for downtown Kingston, an urban area?
I don't think they're bad urban design.
Well, I thought in your statement 12, I don't have it up. I'm just going to pull it. The few large native trees do not function well as urban landscaping.
Yeah.
Well, do you think that goes against the objective of preserving? Well, the KDS wants to preserve and protect stands of mature trees.
Yeah.
And you're saying they're bad urban design.
I'm not saying trees in general are bad urban design. I'm saying this particular case.
KDS is saying that the KDS's intent is saying to preserve and protect stands of mature trees. I guess what I'm trying to get at is your opinion of these trees are bad urban design? Is that a bias, perhaps? When you're okay, that's fine. I think I'll let you off the hot seat. This isn't fun on my side. I apologize, but thank you.
Okay.
Yeah. I think that's it. Thank you.
You're welcome.
Okay. Thank you, Mr. Akahiro. I was just about to ask Mr. Getchis and then also Mr. Beebe if you wanted to cross-examine this witness or call the witness in your case.
I'll just call her in my case.
Okay. Mr. Beebe, do you have any cross-examination for Ms. Schaefer?
I'll wait for David to present her and then cross-examine at that time. Thank you.
I mean, I might ask one question
Okay, sure.
across, just one, and then save the rest for later.
Okay.
Let me see. It's page 190 of the FDocs. If Ms. Walston can pull it up, and I'll pull them up myself later. But for this one, we'll just pull up 190. We were just looking at it.
Sorry, I'm getting there. Here we come. Is it this one?
Yep.
Okay.
So, Ms. Schaefer, looking once again at the significant tree protection design standard in the Kingston design standards, subsection, I believe it's C 1A, chapter 5, C1A. It's a we lost it. We were just there. You go back to right there. Yep. It's a 2-sentence subsection. First sentence being consider alternative building and parking siting strategies to preserve existing trees. Did you, though, consider that fewer than the minimum density allowed was not an option?
At first, I thought 2 was the minimum density as we
But
discussed.
whatever density it was, you can't
Yeah.
go less than that. So you did
Correct.
consider that, right?
Yes. And there's no variance to density.
Right. So that's the only thing I wanted to ask on cross, because that's not the same as not considering at all any alternatives. You considered that alternatives that were less than the minimum required density were not an option.
Correct.
Because you can't do a variance for minimum density.
Correct.
Okay. Nothing else on cross.
Okay, thank you. Mr. Akahito, I'm so sorry. I hope I don't keep butchering your name. Mr. Akahito, do you have any redirect to follow up on the question and answer that Mr. Getchis just asked of Ms. Schaefer?
Just whether or not did you consider alternative building and parking siting strategies within the minimum density requirement?
So I did not. Again, I answered this before. The parcel was so small that the trees would be danger trees even if they were able to be moved all the way to the east. They would still be within that tree length and a half.
Okay. Thanks.
Okay.
You're muted, Ms. Examiner. You're muted.
I just hit the wrong button. Okay. So it is 20 minutes to 11. I do know that one of the witnesses that Mr. Akahito wants to call is only available 10 to 12. That I'm also aware that we're coming up on the approximate 2-hour time that we need to take a break. I'm going to propose that we take a 10-minute break that will allow the clerk to do what she needs to do, make sure that the next witness is available, and we can reconvene at 10 minutes to 11. Does that work for everyone?
That works.
Okay,
Yes.
great. All right.
Thank you.
Thank you.
Recording in progress.
Okay, good morning, everybody. It is 10:52 a.m. on Friday, November 17th. We are back on the record in the administrative appeal of the Main Street Cottages preliminary short plat approval. That's file number 22-02361, and the appeal has permit number 23-02934. When we took a quick recess, I believe we were going to be resuming with appellant's next witness, and it's a bit before 11. So I was wondering if Mr. Mackey is available at this time. Is that who you wish to call next, Mr. Akahito?
We're all lucky. I think we're gonna skip the other 2 witnesses.
Okay, great.
Okay.
And
All
what I totally, just as an aside, I totally forgot to do my opening statement and just
Oh, yeah.
jump. But it's okay.
That's all right. We have the post-hearing brief, so you can tie it all in. Okay. So, Mr. Akahito, do you have any other witnesses you wish to call?
No.
Okay. All right, then. We will proceed with Kitsap County. Mr. Getchis, who do you wish to call at this time?
I'd like to recall Ms. Schaefer, please.
Okay.
Hi again.
Hi, good morning again. I will just remind you that you are still under oath, and I will turn it over to Mr. Getchis to commence his examination.
Thank you. Ms. Schaefer, I'd like to start by showing you Exhibit B1, applicant's Exhibit B1. I'll see if I can pull that up. And go share screen. And, can you see that?
I can.
Let's zoom in a little bit. This lets me zoom. Doesn't actually let me.
If you go to the two bottom right-hand corner, there's two like magnifying glass things. I think that will allow you to zoom in.
Oh, here we go.
Yeah, right
Oh,
there.
yeah. I was just using control and that'll allow it.
Okay, Boomer.
All right.
Oh my gosh, respect everyone.
Okay, so can you tell what area this is, what we're looking at here?
Yeah, that's the subject property.
And when you say that, are you talking the part sort highlighted in green,
Correct.
the green rectangle? Okay, and we're going to be looking at other photos later, and so this is a good photo to start with, just to get an idea of where everything is in relation to the subject property. And how about, can you read the road name on that's running north-south here?
Bannister.
So this is Bannister Street. And then this one doesn't have the name on it, this dead end road, but do you know the name of it?
Yeah, it's Main Street.
That's Main Street. Okay.
And Maine like the state with an E at the end.
Oh, good catch there. And do you know who owns this property over here? This about 1, 2, 3 lots to the.
I think that's the appellant's house, I think.
Okay. That's what I was wondering. And is this, because of the shade here, it's not that easy to see, but is this subject property developed at all?
No, it's not.
So there's no houses or anything?
Correct.
Okay, so like if we zoom in, and what about this driveway here? Is that on the subject property?
It doesn't look like it is, so I'd say no.
No, it's not. That goes to this, and you can barely see it, but there is a house here, but that's not on the subject property either, is it?
It is not on the subject property.
That's on the neighbor's property. Okay, so and the size, do you recall the size of the subject property?
0.37 acres.
Okay, and let's see. Do you know whether, hard to tell again with the shadow here, we might see it in other photos, whether when the village green was built, you can see trees going all around the border, but what about in the shadow here between the subject parcel and village green? Were there trees built there or planted there? Do you know?
Yeah, it's my understanding that the village green did need to provide a landscape plan with their approval that would have required a screening to the UVC zone.
All right, and just for reference, this building right here, what is this building again?
Oh, that's the village green.
Okay,
It's
Village
the
Green
I think it's the senior center or the senior housing of the village green development.
Oh, I see. All right. And this village green has a standard foundation, right? It's not
Yes.
built on stilts or anything, right?
No, it is not. It's
Okay. Are any of these other houses
not on
on
grade.
these?
I don't think they're built on stilts. Did you say stilts?
Or up here?
They all look like they're slab on grade from what I'm seeing.
And then we've got a landmark here, the tennis courts. In other photos from other angles, it's easy to spot the tennis courts, and that'll tell us where to look.
Yeah.
You can't really see, you can just kind of see the edge of these two large parcels here. Do you know what those parcels are? What's
So
on those parcels?
yeah, I think there is a park to the east over here.
Do you recall the name of it?
Cola Cole Park or
Okay, yep.
Cola Cole? Is it Cola Cole? I think it's
All
Cola
right.
Cole Park.
Yes, that's right.
Okay, thanks.
So that's open to the public and people can have potlucks and there's a playground for kids and all that. Is that right?
Yeah, I would assume people could do all those things.
Okay. And now I want to go to A25. So I'm going to X out of this and see if this works. We'll share a screen sharing is stopped. Okay. Okay, can you see this?
Yes.
All right, what are we looking at now? Do you know?
It's the subject property.
Okay, but is this normally there?
Yeah, that's not there.
Okay, so it looks like this is an image that's been altered to show a copy of this single family residence, which is not on the subject property, and the driveway we were looking at in the first exhibit, which is not on the subject property. So none of this is on the subject property.
Correct.
And then there's been a duplicate of the image here. And since this says tree drip lines, presumably to show maybe where the roots go, and that maybe a single family residence could be built here. If this just hypothetically were done, like if your site plan that was presented to you was this, would this meet the minimum density?
If it was a single family residence, no, because
Okay.
it's only one unit. Yeah.
Okay. And let's see. Does this evergreen tree look healthy to you that's circled here?
No, that was the one that Steve Heacock and I looked at that didn't look healthy to us.
What about this one next to it? This little one.
Yeah, it doesn't look healthy either.
Okay. And you mentioned, I think briefly, but again, these trees, we have a critical area section in our code. Is that correct?
Yes, we do.
That defines what a critical area is, right?
Correct.
Would these trees meet that definition of a critical area?
No, there is no critical areas on the subject property.
If somehow they met the definition of critical area, could that affect when you're doing your analysis of what is the developable area, what is the minimum density? Would
Absolutely. Yeah.
These aren't critical areas, right? I mean,
Correct.
if they were, if the code got changed, but they're not, right?
Correct. They're not critical areas.
Okay. And there are also minimum parking requirements too, is that right?
Yes.
Okay. I think I'm going to take you to the next exhibit now. Scroll down. See what this shows. And can you see the same house on the neighboring parcel here and the end of Main Street dead ending here before you get to the subject property? And do you recall the first exhibit we were looking at, I should have asked you, but the bottom of the green rectangle didn't extend to these trees, right? They're across the vacated right of way, right?
Correct. Those are on the neighboring parcels.
Okay. And so in terms of what we're looking at for a possible location, oh, and before I forget, what is this where my cursor is here at behind the trees we're talking about?
I think that's the screening buffer for Village Green, the fence for Village Green.
Fence. What's on the other side of the fence?
Yeah, the screening buffer. So it looks like trees. So typically our screening requirements are trees and then a fence.
And so what's this little piece of a roof? What building was that we were looking at? And then
Is that Village Green? I'm not sure.
I would imagine.
Yeah, I think it is. Yeah, but
and on that side of the fence, you can see, well, it's kind of obscured the rest of it, but at least before I forgot, I wanted to mention that. So, and then are these the two trees that you were a little thought didn't look so great?
yeah. Well,
Okay.
the first one, I didn't see the second one until you pointed it out, but yeah, I see it now.
Okay. Okay, so if minimum density is 4, somehow they've got to fit 4 houses or 4 dwelling units in this little area.
Correct.
Okay. Let's see what else we have. We scroll down. This is a nice picture. And you can see the tennis courts. And then what's this right by the tennis courts? You remember?
That's the Village Green. Yeah.
That gives us an idea of the trees that we were talking about, but it also gives us an idea that these are not the last remaining trees in the area. I mean, so for example, if there was an osprey or something flying over the Puget Sound, and then he comes over Apple Tree Cove here and starts to get tired, you could still land on one of these trees right here.
Yeah, good.
And take a rest. Okay. I'm just going to scroll down to, there was one image. Which one is this? This is number A27. A29. Let's go to A29, which is page 113. So I think I can just go like this and go over the page numbers and go. Okay, this picture here. And so if you take this street address, this is the brown and white house. This is PDF page 113, Appellant's Exhibit 29. And did you have a chance to look up this address 10797 in Kingston at all, or no?
No, I didn't.
Okay. Well, for the sake of argument, if this is single family residence and this was on the parcel, would that meet the minimum density?
If that was on the parcel, no, because it's a single family residence.
Okay. And what else comes to mind when you look at this?
There's a very big tree very close to it.
There is. Do we know anything about the trees that were there before this was built?
No, we don't.
Okay. What about parking for 4?
For 4 units or 4?
Yeah, like on the other one, the minimum parking, well, the parking they've got is 12. Does it look like there's parking for 12 here?
No.
Okay. And then even if there is no apparent destruction to this structure yet, which we don't know exactly when it was built, but does that mean you have no concerns at all about the size of this tree and in a windstorm or something?
I mean, if if I live that close, I would be a little nervous. But it's really based on everybody's personal comfort level with having adjacent trees. So some people may not be as comfortable, others may be.
Okay. And we did spend some time already looking at the Kingston design standards. So let's see. I don't know if we need more on that, but let me just check. And I just wrote these up recently, so that's why I'm otherwise I would just be asking them to you directly.
Well, it's not like you haven't had any other things to do.
I know. It's been a busy few weeks. And then we asked about is there any requirement, for example, of building a house without a foundation or up on stilts or something like that you're aware of?
So the only time we've required that is in a flood zone.
Okay.
To have like the base flood elevation be elevated 1 foot, or have the lowest floor being elevated 1 foot above that base flood elevation. And sometimes that can be accomplished with stilts, but that's the only time we've required it is in a flood zone.
Okay, so is the subject property in a flood zone?
It is not.
In that whole area, that part of Kingston, can you recall ever requiring something that extreme of anybody else?
No.
Based on trees?
Not based on trees, no. I mean, there probably are some properties in flood zones on the shore in Kingston, but outside of flood zones, no, not for trees.
So, for example, in the neighborhood we were looking at in the first picture, where the village green is, where the subject property is, you would have to treat this applicant different than you've treated everybody else in order to make that kind of a requirement, correct?
Correct.
And did you mention this parcel? Is it located? Did you say whether you thought that the applicant could safely meet the minimum density and parking requirements on that parcel without removing the trees?
I don't think that could be accomplished without removing a tree or removing the trees.
And is this in an urban growth area?
It is.
In fact, the comp plan designation, urban high density residential. Is that right?
Correct.
And do we typically have higher minimum densities within the urban growth areas?
We do.
To protect areas outside the urban growth area?
Correct. Yeah. So the densities are lower in the rural zone and higher in the urban zones.
Okay. And protect against sprawl and so on?
Correct. We want growth to happen in the UGAs.
Yep. Okay, yes. I'm now going to go out of the appellant's exhibits and I'm going to go back to the foundational exhibits. So I'm going to close that and I'm going to go to these. And actually, is my screen still sharing?
No.
Okay, so I will then go screen share and go to here. Go share. How about now?
Yes.
Okay, so let's just go to page 212, which is F26. So we'll go to F26, and we're gonna have to first go like this. Go like 212. What are we looking at here?
That's the, excuse me, that's the landscaping plan submitted by the applicant for the preliminary plat.
The landscaping plan. Okay. And what are these for lot A, lot B, lot C, lot D? What are those?
Those are the proposed footprints of single family dwellings.
Okay. And then what about these gray areas with little outlines of cars on them? What are these? There's one in front of each of those houses.
Yeah, that's the parking.
Okay. And so 2 parking spots outside, and then I think wasn't there a garage with
I
another
think so.
parking inside to get a total of 12?
Yeah, I think
8
so.
plus 4. And then what are these circles with little flowery designs inside of them? What are those?
Those are proposed trees.
Is this what you were referring to when you said there will be trees?
Correct, yes.
Okay.
They're required to have landscaping that includes trees.
Okay. And then the species will be decided later, but it'll come from the approved tree list.
Correct. It's conditioned. Yeah.
Is that in the Kingston design standards?
I believe that the list of trees available, like that are required to be on here are in the Kingston design standards.
Okay. Let's go to page 215. What are we looking at here? I think it says what it is down in the lower right corner.
Yeah, that's a grading plan. I think that's with the SDAP.
That's what I was going to ask you about it. So we see a little more detail here, but when you say with the SDAP, what's the significance of that?
That's the site development activity permit, and that is essentially the grading permit, really detailing the ground disturbance of what's going to be built, like the stormwater controls, the grading, the utilities, the driveways, and things like that. That's all considered in this plan.
Okay. And has there been a decision on the SDAP yet?
No, it's still under review. In fact,
Okay.
it's under review.
So if there hasn't been, then you can't appeal that yet, right?
No.
Okay. And then I see Main Street, and then I see it going up. I see the neighbor's lot. What are these stars here?
So those are the trees that were on the other properties to the south.
Okay. Okay, so those are still there on somebody else's property.
Correct.
And then what is this brick looking area here? What is that surface?
So I think those are pavers that are going to serve as the driveway easement for the plat, the short plat.
Okay. I don't have anything else for you now, Ms. Schaefer. Thank you.
Thank you.
Can you leave that up for me, David?
Sure.
Okay.
That's a true boomer. I'm getting David to do it for me.
All right. All right,
Okay.
Mr. Edie, you may ask your questions.
Thank you. Catherine, I'll be brief, said the lawyer. The report of Rick Walsh that we filed at the arborist, he says it's about 80% of the lot when it's developed in accordance with the minimum density is about 80% of the lot is going to be disturbed based on looking at these designs. Is that kind of accurate? Looks about right.
So after the lot is disturbed, 80% of it will be disturbed. Is that what you're saying?
Yeah, about 80% looking at these designs. It's about 80% will have utilities, parking, the buildings themselves, the access road, lighting, and all of that.
Yeah, I think that's
about right?
a fair calculation.
Okay.
Yeah.
Okay. And then if we went back to the drip line pictures that Landon submitted, it's clear that you can't do the maximum density. I'm sorry, Mr. wall says the roots go out to the drip line, basically. So with Landon's pictures, we can see that there would be a significant disturbance of the tree roots with all of this 80%, correct?
Yeah, that makes sense.
Yeah. I thought so too. And then he actually looked at these plans and came to the opinion that you couldn't save the trees, the existing trees, safely. So he looked at these plans. That's all for that. I would go to Amanda. Could I ask you just to pull up F23, the Kingston design standards from the request? And again, I acknowledge I'm a boomer and I could probably do that, but we'd be here another 20 minutes.
Is there a page that you want me to go to?
No, actually, if you just scroll right about there, it's good. Yeah. There's actually almost 75 pages of this document, correct? These design standards?
Yes. Yeah.
And they cover everything from Article 6, which talks about architectural design and requires that these craftsman-style homes be conforming with the neighborhood, surrounding neighborhood. In your opinion, do those little craftsman-style 1-2 bedroom units that are proposed, does that fit in with the character of the neighborhood?
So I haven't seen any home elevations yet, but from the description, the narrative that I asked for that was submitted, it does sound like that the architecture does meet the intent of the Kingston design standards.
Okay.
But that'll further be evaluated at the building permit level when we see the house elevations.
Okay. And then like the final chapter says all utilities have to be underground. That's mandatory. Okay. But there's 75 pages. So this isn't a punch list where you have to hit every single one, correct, in order to build on your property. It's right. And you used your discretion in looking at all of these in recommending approval.
Yes, correct.
Good. Thank you. I like it when people agree with me. And if we could go back to one more applicants, the number 1, B1, Amanda, please.
B1, yeah.
It's the images of the tree removal. And just scroll down to yes, that's excellent right there. This is, and I think on the rest of the exhibit, you would see it's about 2.4 acres of trees. This is from the county records, I want to say 2013, 2014. It shows about 2.4 acres of trees, correct?
I'd have to take your word. I'm not sure about the 2.4, but yeah, that's about right.
I think if you scroll down just a little bit more, Amanda.
Okay, 2.4. Okay, yeah.
Yeah. And all of those are gone right now, except for the 4 or 5 large trees on this property and 4 or 5 smaller trees, correct?
Correct, yeah.
Okay. I don't have any further questions.
So could I ask one thing while we've got this image up?
Sure.
So Ms. Schaefer, just to the left, that's where the village green is now, right?
Correct.
So there were some trees there before.
Yeah, a lot.
Okay.
Oh, a question. To your knowledge, did anyone appeal any of the removals of all these other trees or projects? I don't know how long you've been there, but for the village green or the Pearson property, the senior center, and even the village green parking up above, to your knowledge, was there an appeal of the removal of significant trees?
So the approval for the Village Green came out in 2011, and I started working at the county in 2015. So I
Okay,
would have to look that up. I don't know. I don't think so, but I'd have to confirm.
okay. Um,
I keep doing it backwards with my mute, unmute. All right. Any other questions on direct from the county or from Mr. Beebe before I turn it over to Mr. Akahito?
Not from the county.
None for me, Your Honor.
Okay. All right. Thank you. Mr. Akahito, do you have some cross-examination for Ms. Schaefer?
Sure, just a couple questions. Ms. Schaefer, is there a minimum size for homes in the UVC?
For actual structures, like
Yeah.
actual homes. So we do have a code for tiny homes,
Uh-huh.
or we do have requirements. For example, it has to have a kitchen, at least one bathroom. So there are standards.
How
There's
about
no,
square footage?
I don't think there's a square footage. I think that you have to have certain amenities, but that would be in the building code. So
Okay.
I admit I'm not as familiar with that code.
Sure. And then are alternative foundations allowed, or are they only are they allowed? Like, say, piers or stilts or whatever. Are they allowed as functional building?
So as long as they met the building code requirements, which would be like engineering and things like that, they
Okay.
would be allowed. Yes.
Okay. So just to confirm on the KDS, the Kingston Design Standards, not all the 75 pages are mandatory, correct? According to you.
Well, some of them are objectives, and
Okay.
and it's all case by case basis on a reviewing what you're reviewing.
Sure. But they are given priority, correct? Given the conflict clause.
Yeah, we do review them. We do review projects against KDS as well as code.
With priority.
Yeah.
Okay. Cool. Just looking through my notes real quick. If the county or if the developer demonstrated that they could, well, never mind. I think I'm okay. Thanks.
Okay. Any other questions?
Not from the
Your
county.
Honor, can I just have one more briefly?
Okay. Yes.
Ms. Schaefer, so even if we did on stilts, the 4 structures that are shown in that drawing, you still have to provide 2 parking spaces for each access, underground lighting and utilities and lighting and all of the rest on that property, correct?
Correct. And you would have to meet the building height requirements. There is a limit in the UVC zone.
Yeah, and the stormwater and infiltration and all that stuff. Okay, thank you. Yes, thank you.
Can I just ask one other question? I don't know if you know the answer to this, but do you know anything about open spaces?
Yes.
If part of the land were designated open space, either voluntarily or whatever, would that change the minimum density?
So our open space code, this would be difficult. So open space as in a tax designation, you have to set aside 1 acre for your homestead. And since this is 0.37, it would be difficult to do that.
Okay. All right. Thank you.
Okay. All right. It appears that we are done with examination of this witness. Thank you very much. Mr. Getchis, do you have any other witnesses to call for the county?
No, I don't.
Okay. Thank you. Mr. Beebe, do you have any witnesses to call?
No, Your Honor, we have an engineer and a surveyor on the list, but there's nothing been raised that I think we need their testimony, and appreciate it. Thank you.
Okay. All right. Well, thank you. It appears then that that we can proceed to closing the record as far as testimony and exhibits. Is that correct?
Yes, sir.
From county standpoint.
Okay.
Applicant.
Yeah, that's fine.
Okay, perfect. So we have already addressed closing arguments and set a deadline for submission on Monday, the 27th of November by 5 p.m. Is there anything else that we need to discuss for this appeal, for my consideration of this appeal?
I don't believe so.
No,
Just
not that I'm aware of, Your Honor, applicant.
Okay.
Yeah, we're good.
Yes, Ms. Walston has a question.
Yeah, I just wanted to confirm. So the two additional appellant exhibits, you're going to forward those to me, and then I'll stamp them, label them, and redistribute, and you'll.
Sure, I'll
Okay.
send them right now.
All right.
Cool.
That was my only question.
Okay. Well, then I appreciate everybody's time, and I think we'll go ahead and close the hearing, and I will await final written arguments from the parties, and then we'll proceed to preparing my decision after that.
Great.
Great, thank you, Your Honor.
Thank you.
Thank you.
Thank you, everyone.
Okay, thanks everyone. Have a good Thanksgiving week.
You too.
You as well.
Thank you.